Welcome, everyone. My name is Mark Henriquez. I am the co-chair of the COVID-19 task force here at Womble Bond Dickinson. We're excited to have you join us today for the third part in our Return to Work webinar series. Some of you may have attended those earlier webinars, but we know that companies around the country are struggling with trying to reopen their business, looking at what those legal challenges are, and looking at what they can do to try to reopen in a way that is safe, that complies with the law, that minimizes liability. Today, we're going to focus on one of the areas that's generated the most questions, which is employment. How do we deal with our employees? How do we work with them? And I'm privileged to have two guests with me today to discuss these important topics. One is Beth Jones, who is co-chair of the COVID-19 task force with me. Beth, excited to have you with us today.
Thanks, Mark.
And then we also have my partner, Richard Rainey. Richard is a partner with me in the Charlotte office. Richard, really glad you could join us as well.
Thank you, Mark. Glad to be here.
You know, this is an area that is just part of that big picture of reopening. And I think before we dive in to today we're really going to try to do it in a question and answer process. Beth and Richard have been getting questions from clients, I think, since, now it's been 2 months. It's really since things have started. And so we're going to spend this hour focusing on those questions and really talking through some of the challenges that we're dealing with on an employment basis. But I thought I would start by reminding everybody that this is just one component of what we've been doing. As I mentioned, we have two other parts of the webinar series, and these are now available on our website. If you go to womblebonddickinson.com, you can watch those webinars, look at the slides. One dealt with liability considerations, so we were talking to some of our litigators about what they are seeing in terms of lawsuits. There have been already over 300 lawsuits that have been filed against companies related to COVID-19. So this is not a hypothetical risk. We spent an hour talking about that. We then, in part two, talked about environmental safety considerations. My partner, Brad DeVore, worked with some of the cleaning consultants, and we talked about specific recommendations for what to do in the workplace and how to address those safety issues. We also had a webinar talking to CEOs about lessons learned and how they're dealing with the crisis. And there's a lot more information on our website at womblebonddickinson.com. I think one of the reasons that we're looking at this is that we are in a position right now where we are seeing a lot of issues. And in particular, let's go back and take a quick look at that map because the states are beginning to reopen. And that's something that we are seeing in a number of places. And the states are reopening at different levels. So we've got a map, and you can go to stateclosure.com and actually see what's happening. And it's interesting to me to see this map change every day. It started out as mostly gray because no states had adopted anything. Then we had a nation of yellow as states closed down and had shutdown orders. And now we're seeing that teal color, which are states that are reopening in various levels and degrees. So many are phased. Here in North Carolina, we're in what they're calling phase 1 as of May 8th, where a number of retail stores are open, but other businesses are still closed. There's still a shelter-in-place order. And different states are doing it differently. You can actually go to our website and track what is happening there. I think it's important too, as we talk with Beth and Richard today, to realize that some of those rules are very specific about how to treat employees. And so we're going to try to give general advice today, but we cannot address the specific rules in every state or every municipality where you may have businesses. And so it is important to look at your local rules because they may have very specific guidance about what to do on employees. But we hope that this website is useful to you, particularly if you've got business in multiple states. It's a great way to get an overview of what's happening at the state level. So I guess with that introduction, let me turn to you, Beth, and maybe start. We've got a lot of folks that are contemplating reopening. What are some of the things that they need to start thinking about? What's the process?
Thank you, Mark, and good to be with everyone today. I hope you're all safe and well. As stay-at-home orders are phasing in business reopening, Employers are beginning to contemplate bringing employees back from layoffs, furloughs, or working from home. We're getting a lot of questions. And one thing's for sure, there's no one-size-fits-all answer to the general question of how to bring employees back. The best answers are going to require a multifaceted analysis of the type of business, the size of business, the geographic location of the employer or locations, and the COVID activity there, the layout of offices and facilities, the interaction with the public, the employer's risk tolerance. All the decisions will vary based on a number of factors with employers. We do believe, as employers seek to bring back employees, that they're well served by developing reentry written protocols and related policies, being mindful of a variety of issues like employee screening, wage and hour implications, cleaning and disinfecting the workplace, privacy questions and how to mitigate those, and risks that relate to COVID and COVID possible exposure to your employees and your guests and customers. Invariably, in creating the protocol, employers have the opportunity to think more comprehensively about the ramifications of various aspects of the proposed plan. During a pandemic, some of the rules, although not all of the rules, are changed, at least temporarily, and we'll talk about that, like what the EEOC thinks about the ADA. But when those protocols are finalized and then you communicate them to your employees, this well-conceptualized protocol and reentry plan helps build employee confidence in what is a very anxious time for employees. So it serves as a sound basis to communicate transparently with your employees and inspire some confidence in the return to the workplace. Richard and I have received a lot of questions, as Mark said, from clients in the last 2 months, and we've received questions from some of you even before today. We want to try to answer some of the most common questions with a focus on the employment law issues that have been raised. So let me ask Richard, what are one of the questions that you're being asked the most by clients these days, Richard?
I'd say right now the number one question we're getting is clients wondering about employees that are reluctant to return to work or even refusing to return to work. That seems to be the biggest thing folks are worried about right now. And the answer to that really depends on the situation you're dealing with. There are a number of different buckets that question falls into, depending on the employee involved. For some employees, they're scared because of their own vulnerability. They have an underlying health condition like diabetes or heart disease, or they have a family member that has some underlying vulnerability. Then you also have those employees that are just scared in general. Then you have a bucket of employees that are making more money on unemployment than they are if they were in the workplace. You also have employees that actually have symptoms or are subject to quarantine orders and can't come back for that reason. And then you have the ongoing childcare issues that a lot of employees are having. So it's difficult for them to come back because of those childcare issues. And then I think we're going to have a group of people that, now that they've been teleworking for a couple of months, really like teleworking and are reluctant to come back because of that. So lots of different situations. Let me talk about a few of those. First, for those employees with underlying vulnerabilities, we need to remember that if they have one of those underlying vulnerabilities, like heart disease or diabetes, they're also an individual with a disability under the Americans with Disabilities Act. If that's the case, you need to engage that employee in the interactive good faith process of discussing accommodation options with them. And those accommodation options might be things that can be done in the workplace that allows them to come back and do their job, or it could be leave options under your leave policies, whether that's FMLA or your own policies, or in some cases, creating an unpaid leave of some sort to allow those employees to stay out. And that's what we're seeing a lot of employers doing right now, is that if employees are afraid of coming back, many employers are allowing an unpaid leave option, even if they don't have a formal policy in place already. The next bucket you have are those employees that are just scared in general. They don't have an underlying vulnerability, but with all the noise out there, they're just scared for their own health. And in that case, it's often a matter of education, because they're scared because they're hearing lots of things. They don't have the good context for it. So educating your employees about the facts surrounding the transmission of the virus, the steps that you can take in the workplace to mitigate their risks. And it goes back to, Beth, what you were talking about as far as putting policies and practices in place. The more you can communicate and educate, the better off you'll be. In the best case, that process will alleviate some employee concerns. However, there's still going to be some employees that are just reluctant to come back. And again, with those employees, what we have been seeing are unpaid leaves. But at some point, those employees' fears will become more and more unreasonable, and employers will be more likely to draw the line in the sand and move toward termination. Just as we used to do in the pre-pandemic phase, if an employee was refusing to come to work, well, you've quit your job. I don't think we've gotten to that point yet in the pandemic phase, but as things improve, hopefully, I think we will get there. And then a third bucket is those individuals that are making more money on unemployment than they would be if they were working. And it's hard to blame the first instinct of those individuals if they do the basic math. Well, I'm making more sitting at home, so why should I come back to work? That first instinct, though, can get them in some trouble, because there are a number of states that are being pretty aggressive in having employers to report when they have offered jobs to the employees to come back to work, and are being very aggressive in cutting off the unemployment benefits in those cases. Some states have also said that if an employee remains out on unemployment when there was a job available, that's a possible case of fraud by the employee. So the employee is taking some risk if they're refusing to come back because they're getting more on unemployment. I think if an employee expresses that to you, I think you can educate them on that. Hey, it's not our decision to make with respect to unemployment, it's the state's decision, but they very well could use the fact that you've been offered a position as a reason to disqualify you for benefits. And as I said, some states are requiring employers to report that to the state. So lots of issues surrounding that. Now, of course,
and Richard, that extra $600 is going to run out in July, right? So that we're going to see some change in that dynamic going forward, and employees that may want that short-term money may find themselves truly out of a job and making a lot less money if they don't if they try to play that game for too long.
Yeah, that's absolutely correct, Mark. And I think what we'll see too is that employees will be somewhat savvy enough to cite some other reason why they're reluctant not to come back. So they might cite vulnerability, they might cite something else, childcare, for example. So it'll be interesting to see how they play that and how you need to respond to it. So another group that falls into a bucket are those that have had symptoms from quarantine. Beth, what can you tell us about those individuals?
Sure, Richard. Well, a key containment strategy for an employer is to keep COVID and those that have COVID-like symptoms out of the workplace to prevent additional exposure. So absolutely, those employees that are quarantined or are have symptoms at this time of COVID as they're described by the CDC and public health guidance, they can and should stay out of the workplace. And can they keep working? Possibly, if they're able and they can do their jobs from home. Many employers are having the quarantines, folks stay at home out of contact and continue to work from home. And recognize that that could be for a 14-day period, depending on the reason that they are quarantined. It's possible, and the guidance continues to change. There's public health advice now on critical infrastructure workers and essential workers can remain if they're asymptomatic in the workplace with certain additional steps like face coverings and the like, if they remain asymptomatic for a period of time. But if they can't work from home, what do you do with those employees? Well, as Richard said, employers are providing them leave, sometimes with pay, sometimes a special employer-created pandemic leave, or sometimes without pay. For employees that are with an employer that has under 500 employees, there may also be some emergency paid sick leave that could kick in. So don't forget that. But we're really seeing folks putting people out on leaves, paid or unpaid, regularly. Now, another bucket is those that have child care issues. If we look at Europe, they're ahead of us on this curve. It's difficult to open the economy if schools are closed and child care centers are closed. It's just a challenge. If the employee can't work from home, they don't have child care or schools, then they could use potentially the expanded FMLA that is paid if they're with an employer that has under 500 employees. Otherwise, I'm seeing employers trying to be flexible on this point with leaves, often unpaid, sometimes paid, but often unpaid. Now, what I get the most calls about are employers who believe that an employee just likes teleworking, as Richard says. You know, maybe they really like their new sweats. It's just their preference to stay home. Can they require these employees to come back for work? You know, this is going to raise a lot of interesting questions. For one thing, if the job really requires the employee's physical presence at work, then I think an employer can require them to come to work. You know, right now, so much of preventing the spread of COVID is to maintain social distancing. So if the person can do their job from home, or most of their job from home, many employers are letting them stay at home. But if they can't, they can be required to come back to work. And if not, the employer can take disciplinary action. Now, let me ask you, Richard, what if a group of employees said, we object to coming back to work, or we don't think it's safe to come back to work?
Well, that implicates the National Labor Relations Act, the NLRA, which is a law that a lot of employers that aren't unionized think, well, that doesn't apply to me since I'm not unionized. But really, it does apply to non-unionized employers. And the NLRA prohibits discrimination or retaliation against individuals who engage in what's called protected concerted activity. And concerted means action by a group of individuals, two or more, or an individual speaking on behalf of a group. And a classic example of protected concerted activity is a group of employees going to management to complain about unsafe working conditions. In those cases, the individuals cannot be discriminated against or retaliated against because of that concerted protected activity. And you can certainly envision in this pandemic setting, employees coming forward in a group to say, hey, we're worried about certain conditions. So yes, the NLRA can certainly be implicated when there's group communications like that. So you need to be really careful to not have the knee-jerk reaction of, get out of here, just go back to work or you're fired. you're going to run yourself into some labor issues that you didn't know that you had. So you certainly need to be careful there. Another issue we see coming up where there's statutory protection potentially is under Osha. Osha is another source of possible protection for employees who raise safety concerns about the virus. An employee can actually refuse to work and be protected if there is an imminent risk of serious injury or death. Now, in most COVID situations, that would probably be a tough standard to meet. However, employees can also file anonymous complaints to Osha, and we have seen that happening here in North Carolina, for example. And at this point, and this could change, but the way North Carolina OSHA has been responding to those anonymous complaints is to notify the employer that the complaint has been made, but telling the employer that right now there's no specific regulation that governs COVID issues, and that it's not yet a recognized hazard so that the general duty clause of OSHA applies to them. And they're telling the employer at this point, you don't even have to respond to this letter. We're just letting you know there was a complaint, and here are some resources you can use to make your workplace safe. What we've been telling clients when they get those letters is, yes, we know it says don't respond, but it's probably a good idea to send a letter back to OSHA saying, thank you for letting us know about this, and here are the various steps that we're taking to make sure our workplace continues to be safe for employees.
I think that's really helpful guidance. Beth, I wanted to flip things around. We've been talking about people that don't want to come back, but I know there are also times where maybe the employer doesn't want people to come in, particularly if they are susceptible or compromised. You're worried that they're going to get infected. Can you say, you know, you can't come back, or this group of people can't come back? What's our guidance there?
Great question, Mark. And good examples will be well-meaning employers who are concerned about folks that are over 65, perhaps pregnant women. And they say, I just want to keep them out of the workplace. Actually, an employer cannot do that. There are a lot of laws in addition to the ADA that we've been talking about. Think about the Age Discrimination Act or the Pregnancy Discrimination Act that wouldn't permit us and employers to say everybody in these categories has to stay out of the workplace. Really, what we encourage employers to do is, like we are to do under the ADA, do an individualized assessment about each employee and whether they can be in the workplace. You know, one of the things that's a little bit different for us as employers at this time in the pandemic is we're able to make more disability-related inquiries, even exams. We can ask for medical information. We can screen people in ways that we aren't usually able to do in the workforce. At this time, because COVID is a pandemic, we can make specific inquiries of employees about, do you have COVID-like symptoms? You know, what are your COVID-like symptoms? And that's unusual for us to be able to make those medical inquiries. But here, it's recognized even by the EEOC that these are job-related and consistent with business necessity. So we have some leeway to say, do you have a fever? Do you feel ill? If they refuse to answer those questions, we can bar them from the workplace. You can even do this with applicants. You can ask them about these conditions, these issues, after a conditional offer of employment. So how should we think about it now as far as, can we keep individuals out of the workplace because we are concerned about them being a harm to themselves, being overly susceptible? We really recommend that you keep the focus on a direct threat to others as opposed to themselves generally. That is really the way to go about thinking, is there this significant risk of substantial harm to the health and safety of others that can't be eliminated or reduced by a reasonable accommodation? You apply that direct threat standard on an individualized basis based on a particular employee's disability, not just the condition generally of someone being old or someone having diabetes, but the specific issue at hand using the best available objective evidence. Really, barring someone from the workplace should be more the last resort, and only when they're posing a significant risk. There may be some confusion on this point. Let me just say the EEOC has released guidance on medical inquiries in the pandemic 6 times. They just released it last week. They continue to both adapt to the progression of COVID, but also they release guidance and they realize that maybe it overemphasizes a point or underemphasizes a point, and they're continually tweaking it. And I think that's one of the challenges for employers in managing all these issues with COVID. It's very fluid. With that, employers are concerned. They're concerned about liability to their employees. Most of the clients we work with, I believe, want the best for their employees, but they're also concerned if someone is exposed or becomes sick or even worse. Richard, what about that? What liability do employers have to employees, and what can they do about that?
Well, a few thoughts on that issue. First of all, as Mark mentioned at the outset, we did about an hour on potential liability issues. So if you really want to dive deep into that subject, certainly look up that webinar and you'll get a lot of good information. With respect to employees signing waivers, that's not really a solution for us. Workers' compensation claims can't be waived, and that's what most of these employee claims will be. And whether a workers' compensation claim is one that can be won will depend on whether the virus is seen as an occupational disease, just like asbestosis or heavy metal poisoning might be in some other jobs, or if it's considered an ordinary disease of life, like the flu or the common cold. And this analysis will be industry specific. If COVID-19 is seen as directly related to the workplace, then employees will qualify for workers' comp benefits. And many states have passed laws or regs or executive orders that actually create a rebuttable presumption that a COVID-19 diagnosis was presumed to be a covered disease under the workers' comp statute. Most states that have done this have limited it to first responders and medical providers. However, the list is longer than that in some states. It could be funeral personnel, grocery store workers, pharmacy workers, etc. So the states that have already enacted those broad presumptions, there's going to be a lot of legal challenges on that with respect to whether the disease was actually contracted at work. So we'll see that being a big debate. North Carolina has not done that yet, but it has legislation that is proposing that. So we will see where that goes in North Carolina. Now, as Mark observed, some employees have already tried to sue their employer outside the workers' comp system in hope of getting greater recoveries than the workers' comp system allows. I think those claims will be difficult in most part because workers' compensation statutes preempt other claims against employers except in the most egregious of situations. And I think it's going to be hard for workers to get past those preemptions, but we'll see.
That's helpful, and I appreciate you addressing the issue of having employees all sign some kind of waivers, because I know we've heard that from a lot of folks, thinking that all they need to do is have employees say, I know it's dangerous, or I promise I won't sue. And that's not really a solution that's gonna work. I appreciate that. You know, I want to shift gears a little bit to another area where we've just gotten a ton of questions, and that is around screening and protection. And our poll results are now available. I was very interested to see that almost a quarter of respondents say that they have had an incident of an employee with COVID-19, either testing positive or symptoms already. So this is out there in the workplace now. And for those of you that said no, I know you're worried that when you get back or reopen that's gonna happen. And employers are thinking about screening, they're thinking about protection, they're trying to figure out what to do. They're being marketed a lot of testing options and alternatives from the private sector. And Beth, what are some options? What can employers do? What do we think is permissible, and what do we think may be, actually, practical and effective to help employers take steps?
Sure, Mark. One step in the screening process that a lot of employers are using is a survey or a questionnaire. They're asking some of those questions that public health agencies, the CDC, have told us are important to ask. Have you had COVID-like symptoms? What other risk of exposure have you had? And employers are asking that in writing often. And then they're receiving this document with medical information in it, in essence, about their employees. Again, this is another one of those circumstances we don't normally do this as employers. So what do you do with it when you get the questionnaire or the survey back from an employee and they don't show any positive responses, they haven't been exposed to COVID? What do you do with that piece of paper or that electronic response? If you push this out via email, for example, to all your employees on a daily or a weekly basis. And just remember that the ADA covers how medical information is to be treated confidentially in a separate file, separate from the regular HR file. It has to be kept separately, and while its use is limited, supervisors, for example, can know about aspects necessary for limitations in being able to perform a job, but they shouldn't receive access to the full medical information. So keeping it in a separate file is necessary. But we do see screening and questionnaires as one of the common elements of reentry to the workplace. But probably the thing we get the most questions about is, can we take the temperature of our employees? And I do want us to talk about that a little bit. Very common. Remember, first of all, that taking the temperature of an employee, anyone can be asymptomatic and still have COVID. So this is not a fail-safe test. Employers should carefully consider how to do this. Can they get contactless thermometers that are reliable? That's one of the issues that they need to determine. And then if they can, who is going to take the temperatures? Is it going to be, do you have some healthcare professionals, those that are trained to do this? Or are you going to have other employees do this? Let's remember you need some PPE for those employees that are taking the temperatures, gloves and masks. Many employers are turning to contractors to do this. And of course, where there's disruption, there's opportunity. And there have become a lot of contracted providers who are available to take temperatures. Some employers have decided, let me say, as you're working out how to do this, employers are realizing that it could take quite a bit of time to take the temperature of employees who are all reporting at a shift change, for example, or reporting to work at the same time. So you really have to work through, do you want to stagger some start times so that you can relatively efficiently get folks through? At some of our clients, employees remain in the car. They use the contactless thermometer. You need to consider, if they're non-exempt employees, is this time waiting and then getting your temperature taken or filling out a survey? Is this compensable time under FLSA? And also state law. And the answer can differ based on the states that you're in, as well as your business. There are times when indeed it might be compensable. And some clients I work with have decided in some locations it might be compensable. We're just going to compensate for that time. Others are working to find the most efficient way possible to work people through the screening. I've even got employers who are asking employees to take their temperature at home and then report that on the screening or the survey that they are submitting every day. And that is absolutely an approach people are doing. I would say that I want us to talk about other forms of testing, but I want to flag those FLSA and wage and hour issues. We really see them pop up throughout a lot of COVID-related circumstances. Definitely compensable time questions in screenings, but also non-exempt personnel working from home, being sure that we're capturing all the time that they're working, exempt employees who come back to the workplace and have to do extra cleaning duties if they end up performing a lot more, spending a lot more time on non-exempt duties. Would that change their classification? It even can arise in how employers go about salary reduction. So I just want to flag that as an area that could trip you up. But sticking with screening, Richard, I'm hearing a lot about and seeing a lot about antibody testing or serology testing. Should employers be considering that?
Well, they're certainly considering it. That's a question we are getting from our clients, and they're asking, can we do it? And the answer to that is clearly yes. Under the current EEOC guidelines, you can do the testing. The second question, though, is should we? And I think that's a more complicated answer because first you have a real accuracy issue with either serology testing or antibody testing. That may be getting a little better as the tests get better, but you still have to do a lot of research on the front end to see if the test that's being proposed to you is actually accurate, or am I going to get a bunch of false positives and false negatives? And that really defeats the whole purpose of testing if that's the case. The second issue you have, though, after accuracy is, in my view, what is the effectiveness of it? What are you really accomplishing with testing? Because with serology testing, we're just talking about a snapshot. So I took my test on May 10th. I know that I don't have COVID-19, but what does that really mean? I can go to work tomorrow on May 11th and be infected with it, or on May 12th, or a week later. So the fact that I have it on May 10 doesn't really provide me with a whole lot of effective guidance. The same thing with antibody testing. If I have the antibodies, it means I've been exposed to COVID-19 at some point. But what the science doesn't tell us yet is whether those antibodies then provide me with immunity. And in the ideal world, we would get immunity passports. If you have the antibodies, that means you can go anywhere and you're not going to get infected. But that's not the case right now. And so until we get the science that supports that, I'm not sure what antibody testing does for you, because you may have the antibodies and get reinfected. Or even worse, get reinfected, but because you have some antibodies, be asymptomatic, but still be able to pass the virus on. So at this point, I'm not sure how effective serology or antibody testing really is for employers, but it's obviously an issue on which reasonable minds can differ. And if other people have different views, I'd be happy to entertain them.
I think that's great, Richard. I think that's a good point. And I think some of those same points apply to temperature testing. And this is something Beth said that I just wanted to emphasize too, in terms of it not being a fail-safe. I know they did a survey of people that actually came to the hospital and tested positive. Only 30% of those folks actually had a temperature. So you may catch some people with a temperature, but there are a lot of people that may be asymptomatic or even have other symptoms like a cough, but not have a temperature. So while I think you can do it and you have to follow the guidelines Beth outlined, I think it's worth being very thoughtful as an employer about what are we really going to do? Are we going to create a false sense of security that, oh, I don't need to worry about social distancing or a mask or anything because everyone got temperature tested? And I think the reality is that that's just wrong, right? The temperature testing may be moderately useful, but a lot of people aren't going to be picked up. And so I think you need to worry a little bit about what the message is and creating some sense of it's fine, everybody's temperature tested. So that's a good, that, you know, I just think it's worth thoughtful, and there's a lot of written about it and different people have different views, but I think it's worth being thoughtful. Before we leave testing and screening, we did get a question online that's a good one about records. I think everyone understands that these are confidential medical records. I think the question we got is, do those have to be kept in each individual's medical record file? So you're filing, you know, every survey, and if it's a daily survey, going into all 100 folders, or can you create a new but confidential COVID-19 symptom folder? Any advice either of you can give on how those have to be kept? Because obviously you're potentially talking about a lot of medical records being generated on a daily basis.
Richard, I don't know if you've had clients. I don't have a lot of clients doing this in paper, number one, but you may. And I do think the primary thing is to keep it confidential. I don't know that they need to be listed by each individual employee. So I'm not envisioning a file folder for each person. Rather, I'm envisioning that they are not available to anyone, for example, outside of HR. They're kept confidential in that setting. But Richard, do you have other ideas on that?
I agree with that. I think there's no requirement that you file them separately. You could have a COVID-19 file that captures all of that, as long as you keep it confidential and keep it on a need-to-know basis. The other question we're getting a lot of with respect to protections are masks or face coverings. And sometimes we need to make the distinction between a mask and a face covering because they can be two very separate things. And the CDC is certainly recommending masks and face coverings for individuals when they go out in the public. State and local orders are very different on whether face coverings and masks are recommended or required. So you need to look at your local orders on that issue. Obviously, there are some occupations where they're required as PPE, and we get questions about whether we have to pay for that. And typically the answer is yes, the employer does have to pay for those things. If it's not required, should the employer be providing masks for employees? We think that's a good idea, and we think employer picking up the expenses for that is a good idea. Another question we've gotten recently is, what happens if we're requiring face coverings, but an employee is refusing to wear one? What do we do in those cases? And the way I've looked at it is it's sort of two separate tracks. One is if the employee is uncomfortable wearing the mask for whatever reason and would prefer not to wear one, that's really a safety violation, a safety rule violation that you would treat like any other violation of a safety rule, which would typically be your progressive discipline path. But there's also another track where the employee doesn't want to wear a mask because of some underlying disability, because it makes it difficult for them to breathe, or they have anxiety issues, or whatever it might be. And in those cases, you have to take it down the ADA reasonable accommodation path, explore with them what options there might be. Might there be another mask that they can wear that makes them more comfortable? Might there be a face shield that they can use instead of a mask? And really explore what those options are. Certainly leave options may be available. But before you fire somebody or discipline somebody for refusing to wear a mask, you should really understand what's the reason that they're citing for that. So don't have a knee-jerk reaction of immediately imposing discipline. Ask some questions, make sure you understand what the facts are, and then decide what path you need to go down. Beth, do you have any other thoughts on that?
Well, just to the point you're making, and Mark as well, in order to return to work, you're going to likely need to possibly create some barriers in your workplace, create some social distancing in your workplace, possibly do things like close break rooms and take different steps like that. And if employees refuse to follow those guidelines, thinking about them like safety guidelines, as Richard said, is a good way to approach it and treat it like you would other issues like that at the company that you experienced pre-COVID is always a good approach. We do know
discipline in connection with not wearing a mask. What if they refuse to do a test, refuse a COVID-19 test, refuse a temperature test? What option should employers be thinking about for those folks?
I think that you can, if for example, we know very clearly if an employee refuses to answer a questionnaire, a COVID questionnaire, that we can send them home. We can ban them from the workplace. Likewise, if they refuse a temperature test, we can refuse and send them home. So you absolutely can do that. The point is it's a safety rule, right, for everyone, and we're definitely able to do that. I think it's always good to ask what's going on in case it might be an accommodation issue, a disability issue, but in general, yes, you can keep those folks out of the workplace.
Richard, it looks from our poll, only about a third of the people that responded have more than 75% of their folks back. So we've got folks that are going to see people coming back to work, and obviously that timeline is going to vary business to business. But inevitably, we may have people coming back that end up testing positive, either through workplace testing, or they simply go to the doctor, or you hear about someone that is tested positive and has symptoms. How do you handle that as an employer when you find out you've got a positive person?
Yeah, it's sort of depends on the timing of it. Obviously, the testing part of it, they might not be in the workplace when they test positive, but they may have symptoms in the workplace that cause them to be tested, and then you find out they, in fact, did have COVID. The CDC actually has really good guidelines for employers on what to do, sort of a step-by-step process. So I'll highlight just a couple of things. First, obviously, if somebody's having symptoms in the workplace, you need to separate that in, and send them for medical consultation. If it turns out that employee has tested positive, you have to then do the contact tracing to see who they've been in touch with, who they have had close contact with, in order to advise those people as to what next steps they need to take. Now, one thing that I do want to talk about is this idea of close contact. And it's been a bit of a moving target when you read the guidance that's come out. Early on, when we were talking about close contact, all we were talking about was being within 6 feet of somebody that was infected. We're starting to see that shift a little bit, in that close contact is now being defined as an element of distance and time. So it's within 6 feet for a certain amount of time. And I've seen that time expressed as 10 minutes. I've seen it 15 minutes. And that seems to be guidance that is changing. So if you do have an employee that tests positive, one of the things you need to think about is, okay, how are we defining close contact? Is it going to be within 6 feet and 10 minutes? Or is it going to be something that's much more conservative, so that if you just passed down the hall and went past somebody, you're within 6 feet, you automatically have close contact? I think what I see in the literature is it's trending more toward distance plus time. But that's one of the things that if you have a case, you need to look to see what the latest guidance is on that point.
When you're doing contact tracing, Richard, do you share with the folks who was positive? In other words, if you find out Joe Smith is now positive and that he did have close contact, however defined, with Mary, do you tell Mary, Joe's positive, you need to be concerned, or do you say somebody is, positive? How do you handle that balance of confidentiality and, and telling someone, and what if Mary has only worked closely with one or two people and can figure it out anyway? How do you deal with that?
Yeah, the default is not to tell the name of the person that has been infected. So in the best of worlds, you would do that. Now, one thing you can do is for the individual that's been infected, when you ask them, who have you had close contact with, you can also ask them, would you allow us to share your name? And if they say yes, that's fine, then you can share that person's name. If they say, no, I'd rather you not, then you certainly don't want to share the name. But to your point, a lot of times people can figure out who it is anyway as a practical matter. But yeah, the default is not to share the name of the person that's been infected.
That's helpful. Beth,
Now, one exception on that, sorry, Mark, one addition to that, Richard, is if the employer can tell a public health official of the name of the employee that tested positive. And if you've got a contractor situation, the contractor can tell the employer, you're able to tell the site where the exposure has been, I think, under guidance.
Yeah, I think that's right. And I think one other point that came up in our last seminar or webinar, which I think is an interesting one. If you look at the guidance, it says that if you've had somebody with an infection in the workplace and they've been at work, ideally you should wait 24 hours before you start cleaning the places where that person has been. I think as a practical matter, that's going to be really difficult to do. And the guidance does say ideally 24 hours, but when practicable. So a lot of times that's going to be immediate cleaning, but that is something that 24-hour guideline is floating out there, and people need to understand what it is.
That's a great point. It's causing some employers to realize they'll just shut down for that time period for the deep clean, right? Depending on what their facility situation is.
Yeah, it'll be very difficult in most cases, I think, to cordon off entire areas of your workplace and not allow them to be accessed at all for 24 hours. So I think most times you'll be cleaning sooner than that. But again, you just need to be aware of what the guidance is.
Beth, I know you spend a lot of time thinking about the future of work and looking around that next corner. I'm interested in your thoughts about what may be coming up. We've talked about some of the issues we're hearing about today, but what are we going to be hearing weeks, months, a year down the road?
Yeah, Mark, one of the things I look so forward to is a day when we have a vaccine for COVID, right? Wouldn't that be terrific? It'll be great to have a vaccine, and I think our employer clients will say, can we require our employees to be vaccinated? And I think that we can require it. Employers will be able to require it, but we'll need to consider accommodation requests both by those employees that have disabilities, as well as medical conditions, as well as those employees who may have a sincerely held religious belief, and they may ask to be accepted from a requirement to be vaccinated. A lot of commentators think that this rapid move to work from home is going to increase the amount of teleworking. It's going to increase it going out into the future, and this is something that many employers have spent a lot of time resisting. They have resisted agreeing to let employees work from home. And they're finding in some cases that employees are being very efficient now, and they may agree to that, so much so that it may change the amount of office space that they have going forward. There's also a thought to me that employees are working from home doing as much of their job right now that they can because they have to because of COVID, but they're not doing the whole job. They're just doing a lot of the job. And I think what this will cause employers, it gives us the opportunity to refine what are the essential functions of each job, which we know as employers is critical for future accommodation requests and so many employment-related things. So it lets us focus in on what are those critical aspects. And maybe there is an aspect that requires in-person collaboration, even for office-related jobs. But I think it gives us a chance as employers to think differently about work and to identify what are those real essential functions of a job. Richard, other thoughts on what might be coming around the pike?
Yeah, I think as we move through the different phases that are planned right now for getting back to work, I think a lot of employers will be grappling with not so much the can we question, but the should we question. So for example, as guidelines say, you can now have gatherings of up to 50 people. I think a lot of employers will say, well, we can do that, but should we do that? Is that the smart thing to do? The retreat that we normally have, where we have 100 people and we're now in phase 4, we can do it, but should we do it? So I think over the next months, those are the questions employers will be grappling with. And sometimes the answer will be, yeah, we can do it, but it's not really smart to do it, especially until a vaccine is developed and we've gotten a really good grip around the spread of this virus.
I think that's a great point.
Mark, but things are going to change and COVID won't be as acute and it won't be as pervasive and it won't be a pandemic. And these questions that right now as an employer we're able to ask, we won't be able to ask. Likewise, those employees that are so concerned and nervous about coming to work, at some point that won't be reasonable. Our answers for what the employer's response should be will change as the circumstances change.
I think that's true. And I think it's interesting to see the range of responses. Obviously, we work with a lot of different clients in different industries, but we've had some that say, we're not even going to do in-person meetings, for the rest of the year, or we're not going to open up our office to people that can telework for the rest of the year. Pretty broad long-term restrictions. Others are bringing people back, as we speak, or making plans to bring them back next week, the beginning of June, bringing them back in shifts. It's not always a binary decision, but we are seeing a broad range. And I think it is useful to, talk to people in your industry, talk to peers, see what's going on, because we are seeing an evolving standard. One thing I've seen from a lot of folks is, and I know some people on this call are essential businesses that have been opening and have been dealing with this social distancing. Others that are just reopening for the first time are trying to figure out some of those rules. And I think we do have some of those lessons that we can learn, from those other companies. I know we're almost out of time, and I haven't been able to answer all the questions. We will try to answer those of you that we didn't get to separately. We have also committed to put together an FAQ sheet of the most frequently asked questions, so you have something to take away. That's something that we'll email to all of you as participants, as well as links to the first and second webinar in this series. And we do have resources available on our website. I've got a screen that'll show you our resource hub. We've got over 50 different articles and alerts about various issues, including the employment topic. You can subscribe for a weekly digest if you don't want to get an email every day, and you can do that. And also we've got a YouTube playlist that is available as well. So there are a number of resources that are open to you, and we encourage you, to look at those. And again, we appreciate the questions, and sorry we couldn't get to all of them. I know we've had a number both in advance and here. So look for that FAQ list to be emailed to you. And also, of course, feel free to reach out to Beth, Richard, or myself if you've got follow-up questions or something we didn't get to we're happy to try to provide assistance. Thank you all for attending today. I think this has been a great dialogue. Beth, Richard, thank you so much for this information. We hope everyone enjoys the rest of the week and look forward to talking to you next time.